here today. I'm going to start by getting my slides up on the screen. As Marianne mentioned, I'm a litigator in private practice, and among the matters that I have to touch on in my practice are advising and representing clients on matters relating to their obligations under our federal private sector privacy legislation, which is the Personal Information Protection and Electronic Documents Act. That's a mouthful, so it typically goes by the word PIPEDA or PIPEDA. You pick your pronunciation. I'll just start with the disclaimer that I'm not here to give any legal advice today. I'm intending to provide a bit of a primer or an overview of what PIPEDA is, what it deals with, what we can find in there on areas that may be most relevant to your work as mediators. But you should, of course, consult with your own lawyers and get legal advice specific to your situation on anything that may touch on your individual obligations. So hopefully everybody can see my slides okay. I'm getting the thumbs up. Excellent. Okay. So just to begin, what is PIPEDA? Or the Act, as I'll call it from time to time today. In a nutshell, as I said, this is our federal private sector privacy legislation in Canada. And the main operative part of this Act, Part 1, focuses on the obligations that private sector organizations have to protect personal information that you come across in the course of your commercial activities. The Act governs collection, use, and disclosure of personal information by organizations. And at the conceptual level, the Act really tries to strike a balance between the privacy interests of individuals in respect of their own personal information. We all like to be in control of our own personal data, with the fact that organizations who are engaged in commercial activities need to collect, use, and disclose personal information for their own business purposes. And if we stray, the pendulum swings too far to one side or the other, it's a problem. We're either unduly infringing in individual privacy matters, or we're stifling the needs of the commercial needs of organizations. So the Act is really trying to walk a line between these two competing interests. So let's begin with, when does the Act and obligations under the Act apply? What the Act tells us is that the obligations in the Act apply to every organization that collects, uses, or discloses personal information in the course of commercial activities. And then there's an or about employment context. I'm going to talk, not really going to focus on the employment side of things today. So there's a few things we have to unpack in that sort of broad statement of the application. We need to know what qualifies as an organization. Probably many of you listening to me are saying, well, I practice family mediation. Am I an organization? That doesn't sound quite right. So we have to understand what's an organization. We have to understand what is personal information. And we need to understand what is meant by commercial activity or in the course of commercial activity. So I'm going to start with the last one. Commercial activity for the purposes of this legislation means any transaction, act, or conduct or regular course of conduct that is of a commercial nature. I mean, it sounds like we're sort of in a bit of a circular definition there, but this is intentionally extremely broad. It includes selling, bartering, or leasing, excuse me, membership lists, fundraising lists. But really, to boil this down to its simplest, when you are selling services or products for commercial reasons for profit, that's commercial activity. So that would include selling mediation services. That's conduct that you're engaging in for a commercial purpose. That is your business. Okay, so it's captured in there. What I do as a lawyer, the legal services I provide, it's for a commercial purpose. That would be captured as well. Okay, so the two other things we have to unpack here. The next is, what's an organization? And again, we see intentionally a very broad definition. An organization is an association, a partnership, a person, a trade union that engages in commercial activities, as I've defined it. So yes, you can have an organization that is one person. You don't have to, be part of some big group or corporate enterprise in order to be an organization. So think of this as very broad, but then there are some exclusions. Government institutions are excluded here. I said this is private sector legislation. There's a whole other statute that applies to government institutions. That's the Privacy Act. So it's not like they have no privacy obligations. It's just a different regime. Individuals who collect, use, or disclose personal information for personal or domestic purposes and not for any other purposes, they're not an organization. And that sort of makes sense too, because if it's for personal purposes, it would not be commercial activity either, right? So sort of on both fronts, you're not captured by this act. And then organizations that collect, use, or disclose personal information for journalistic, artistic, or literary purposes and nothing else, they would not be captured. All right, and then the third component we need to unpack in order to understand the application of these obligations is what is meant by personal information. Again, we see a very broad definition. Personal information is any factual or subjective information about an identifiable individual. Information about an individual. Identifiable individual is not defined in the Act, but we've had courts tell us that that means there's a serious possibility that the information, either alone or together with other information, could be used to identify the person. The information doesn't even need to be correct or accurate in order to constitute personal information. So it's really, again, quite broad. Almost anything about a person. It would not include aggregated information about a number of people that sort of brought together would not permit any of those individuals to be identified. So, companies can aggregate their data and release it in sort of statistics form because nobody can be individually identified that way. Or if the information is anonymized and generalized enough that it could not lead to the person being identified. And so if you were to give a talk and in a very general way say, I had a client who came to me in the year 2020, and you're sort of using it as a teaching example without saying anything specific about that person, you've sort of brought it up to the level of being so general that they can't be identified. That would likely be okay. Okay, so some examples of what would amount to personal information. Age, name, SIN numbers, driver's license, identification, personal address, personal home address or phone number, contact information, email address, income information, health or medical information, religion, ethnic origin, employment records, credit records or other financial records, even their opinions or comments, professional disciplinary records. I mean, these are just examples. It's, you know, I couldn't be exhaustive on this if I tried, but just to give you a flavor. The Act tells us that personal information does not include business contact information, where it's being collected, used, or disclosed solely for the purpose of communicating in the context of that person's business or employment. Okay. All right, so that's a general overview of when PIPEDA applies or who has, broadly speaking, obligations under PIPEDA. Who needs to know about this? If you are captured by those things I talk about, you need to explore further your obligations under PIPEDA. So now let's talk a bit about the sorts of obligations that are triggered if the Act applies in the way we've just discussed. There's a schedule to the Act, Schedule 1, that sets out 10 fair information principles for organizations to protect personal information. These principles, which are sometimes referred to as a model code for protecting personal information, they form the ground rules for organizations' collection, use, and disclosure of personal information, and for giving access to personal information. These principles are what give each of us as individuals control over how our information is handled by private sector organizations. Time is not likely going to permit me today to go through every single one of these principles, but I've put them on the screen so that you can at least grasp the sorts of things that we find in Schedule 1 that are discussed and unpacked, and there's actually quite detailed information about each of these principles. So first, it's accountability. No question, organizations are accountable for what they do with respect to the personal information that they collect, use, and disclose. Identifying purposes. What the Act tells us, and I'm going to say more about this in a few minutes, but what the Act tells us is that information is collected, used, and disclosed for particular purposes. If you as an organization want to collect, use, or disclose personal information, you need to be clear on why you're doing that. You need to identify for your own organization, and more importantly, for the individuals whose information you want to collect, why you need it and what you intend to do with it. So these principles speak about identifying your purposes. Third is consent, and this is really an overarching principle, and I'm going to talk about this a bit more. Consent, to be valid, to be actual consent, has to be informed, and it has to be meaningful. And so we're going to talk about some of the things that can be done to comply with obligations on consent. Number 4 is limiting collection, that we only collect what we need, what we have consent to collect, what matches up with the purposes. We have to limit use, disclosure, and retention. That's principle number 5. Number 6 is accuracy. We have to try and ensure the accuracy of personal information that we hold. And if we come across information that the personal information we have is not accurate, we have to correct it. Principle number 7 is about safeguards. Safeguards are the mechanisms that organizations put in place to protect the personal information that they hold from unauthorized access and disclosure, firewalls, encryption systems, that sort of thing. If you've got it, you have an obligation to protect it. Number 8 is about openness. I'm not going to talk as much about that today, but this is where we see principles relating to telling people what your privacy policies are and how individuals can obtain better information. And this leads into number 9, which is individual access. We all have a right to know, generally speaking, what of our personal information organizations are holding and to access that information. And then 10 is principles dealing with challenging compliance, having accountability and responsibility in the event that there wasn't compliance, or at least there are concerns about non-compliance. Any discussion about PIPEDA and the obligations and rights under PIPEDA necessarily involves an introduction to the Privacy Commissioner of Canada and the Office of the Privacy Commissioner of Canada, or the OPC. The Privacy Commissioner and his office, the OPC, have the overall responsibility for overseeing compliance of organizations with their obligations under PIPEDA. I'm going to talk about this at the end, unless I run out of time. And so PIPEDA, the OPC is really a resource available to members of the public when they have a grievance, when they have concerns that their privacy rights may not have been respected by an organization. And the OPC, in addition to investigating complaints of non-compliance, also has the authority to, or the mandate, I should say, to put out guidance and information sort of proactively to help organizations comply with their responsibilities. And so, many of the things I'm talking about today, you can learn about more just by going to the OPC's website and reviewing some of the guidance documents that they put out there. Or if you ever have questions about what your obligations might be, you can reach out to them and look for that guidance as well. How am I doing for time? Perfect. Okay. So before I get into some of the more specifics about certain of the obligations, in particular consent and the need for valid consent, I just want to speak at an introductory level about the overall parameters of compliance and what needs to be done to comply. First and foremost, if you take nothing else away from today, the one thing I'll sort of drill on is that organizations, as a general matter, must obtain an individual's consent to collect, use, or disclose that individual's personal information. There are exceptions that I will come to, but as a general matter, each of us has the right and the authority to give or withhold our own consent to the collection, use, or disclosure of information about us. Secondly, every single one of us, has the right to access our personal information that is held by an organization and to challenge the accuracy. If they've got it wrong, we have a right to pursue that and get it corrected. And thirdly here, as a general matter again, personal information can be used only for the purposes for which it was collected. Remember when I went through those 10 fair information principles, identifying purposes was one of them. If you've told somebody, I need these categories of personal information from you for the following purposes, for the following reasons, and then they give you the information and you pivot and use it for something else, that's a problem under PIPEDA. We can't do that. Okay, so let's get into consent in some more detail here. In most situations, as I said, individuals must consent to the collection, use, or disclosure of their personal information. The consent principle, fully unpacked, requires both knowledge and consent. They go hand in hand. Informed consent. It's not really consent if it's misinformed or uninformed. For consent to be valid, the Act tells us that it must be reasonable to expect that an individual to whom an organization's activities are directed would understand the nature, the purpose, and the consequences of that organization collecting, using, and disclosing the information. Again, that's a bit of a mouthful, so to sort of paraphrase that in my terms, for consent to be meaningful, individuals must understand what they are consenting to. Why? Why am I giving you this information? And organizations should identify and document, again, keep a record, because if the OPC comes knocking, you want to show them that you've got all of this. Identify and document your purposes and disclose to the individual why you're asking for the information, either before or at the time of collection. If it comes after, it's no good. That's not informed consent. So what we're talking about here is making a reasonable effort to ensure that when you're collecting someone's personal information, you have told them what the purposes are for collecting it. And so you need to state this in a manner that the individual can reasonably understand so that they can make that decision to give their consent from a position of being properly informed. So there's a few questions you can ask yourself to help in fulfilling this obligation to collect valid consent and disclose your purposes in doing that. Ask yourself, have I made clear to this person what information I'm asking for, what's the nature, what my purpose is, and what the consequences to them might be if they give me the information? Can I be assured that the person I'm dealing with reasonably understands those things? Ask yourself, am I collecting this information only to fulfill an explicitly specified and legitimate purpose? I mean, it's another way of saying the same thing. Have I made it clear precisely why I'm collecting it? And have I made clear that my purpose is connected to the relevant commercial activity? If you're providing mediation services, you should be able to articulate why the information you're collecting is relevant to those mediation services. One of the questions here is about how integral the information is. We can collect information that is integral to what we're providing from a commercial standpoint. We can also collect non-integral information, and there are differences here. Let me illustrate this with probably a not very relevant example, but one that I hope makes the distinction easy to grasp. Let's say that I buy a subscription to a magazine. I have to give the publisher or the distributor my address so that they can mail my magazine to me. If I don't give, I have the right to refuse to give them a mailing address, but then they can't give me the magazine, right? That would be considered integral information as part of the commercial transaction. I have to consent to give them that information for the purpose of sending me my magazine. However, I do not also have to consent to them using my address to send me ads and solicitation for other magazines that I have not subscribed to. So I can refuse consent to that non-integral purpose. They still have to send me the magazine I want, but I can refuse, the promotional mailings for the other ones. So I hope that helps illustrate the distinction between integral information and non-integral. And if it's non-integral, the person must be given the choice to refuse consent while still engaging in the main commercial transaction or activity. How you seek consent must take into account the sensitivity of the information that's being collected, used, or disclosed. If you reflect back to the examples I gave you of what qualifies as personal information, you can see that they really fall on a spectrum. There's information that is highly sensitive, like medical information, credit scores, that sort of thing. And there's personal information that's at the low end of the spectrum, my Gmail address, even potentially my home address, my age. That's not particularly highly sensitive, but the higher up the scale we get, the more cautious we need to be about how we are requesting consent. I'll say more about that in a moment. The final point I want to make about obtaining valid informed consent is respecting the right to withdraw consent. Barring legal or contractual restrictions, with reasonable notice, individuals have to be able to withdraw their consent at any point. Say, yeah, I know I gave you that information. I now want you to delete it, and I don't any longer consent to it being used or disclosed. Generally, we need to inform individuals of the implications for withdrawal of consent, but it's still their right to consent, even after the fact. Okay, so how do we do our best to ensure compliance with our obligation to obtain consent in collecting, using, and disclosing information? We need to ensure that when we collect information, it's readily available in complete form. Remember, I said everyone's got a right to access the the personal information that private organizations hold about them. So if someone comes knocking and says, I want to know what personal information you have about me, you've got to be able to find that and pull it together. And so you should have a system for that. You should provide information about your use, collection, disclosure of personal information in a meaningful and easily accessible way. There's lots of examples out there of privacy policies. You can, if you don't have one, you can develop one or get assistance in developing one that is appropriately tailored to your services. But anyone should be able to get from you a clear statement of what information you collect, why, how you use it, when you disclose it. You should obtain consent when making changes to any of your privacy practices. That includes if you've already collected the information for one purpose. As I said, it's not permissible. It's a no-go to suddenly pivot purposes and use that information for a different purpose that you didn't disclose without consent without getting new consent. So if you hold the information and if you identify a new purpose that you want to use it for, you have to communicate that new use, that new purpose of disclosure, and get fresh consent at that point. Again, you need to ensure that you're collecting, using, and disclosing the information only for purposes that a reasonable person would consider appropriate under the circumstances. And you want to emphasize in your communications with individuals the following points. With precision, what is it that you are collecting? With whom might you need to share that information? What are your purposes? And what are the risks of harm or other consequences that could follow from granting consent to collect, use, and disclose the information? I mentioned that how we seek consent can depend on the sensitivity of the information that we are collecting. Express consent is required as a general matter for collection, use, or disclosure of sensitive information, the higher end of that spectrum. For collections, use, or disclosures that may be outside of what we would reasonably expect. You know, again, if I'm signing up for a magazine subscription, I'm going to expect they need my address. But if they then go on to ask about my credit history, I might need to ask some questions, or I would want to know a bit more about why. And we need express consent for any collections, uses, or disclosures that create a meaningful risk of significant harm. That's another defined term that I'm going to speak more about. When it's children involved, when it's the personal information of children, we get consent from a parent or guardian. And really what we're talking about here is anyone under the age of 13. When we get into that older category of adolescents or youths 13 and over, they may be able to provide consent themselves, but you have to put in place a process to get consent that is reasonable considering their level of maturity. Okay. One more thing I'll add, although it's not on the slide, is while saying we need express consent in certain situations, there are other situations at the lower end of the spectrum where consent can be implied, or we can do it by sort of opting out. And we've all seen those sort of forms. You fill in a form with your address, phone number, email, and then there's a box they want you to check to say, you know, do not, you know, send me promotional emails, or, you know, do not share my information with any other organization. That sort of an opt-out can be okay in some circumstances, but definitely not in these three areas where I said express consent is required. That's an obligation under the Act. Okay, there are a number, so we've talked about all of this as general principles. Now I'm going to tell you that the Act sets out certain circumstances where consent and knowledge are not required for collection, use, and disclosure. I'm not going to go through all of these. What's most important is that you understand the general rule is knowledge and consent, and then there are exceptions. It's not the other way around. So if you don't find your scenario in one of the exceptions, you must obtain consent. And these are rather specific, these exceptions. General rules, specific exceptions. So for example, where collection is in the interests of the individual and we can't get consent in a timely way. There's another there's other exceptions that speak about sort of emergencies. So while if there's a medical emergency, someone is unconscious, we need to know their allergies or their blood type in order to provide medical treatment. They can't consent in that moment, but it's clearly to their benefit. So it may be okay to check hospital records or medical records without their consent in order to collect that information. It's clearly in their interest that we know, are they going to have a reaction to the treatment I'm administering? There are exceptions where if we went to get consent, it would compromise investigations of alleged breaches or contraventions of laws. So police may not always seek consent to collect personal information about the suspects that they are investigating. Police is not the best example because they'd be captured under the public sector legislation, but again, I'm just sort of illustrating the point. Other interesting examples where the information is produced in the course of someone's employment and collecting it is consistent with the purpose for which it's produced. Again, we see this interesting carve out for journalistic, artistic, or literary purposes where the information is publicly available. So these are the sorts of narrow circumstances where we don't need consent. Similarly, there's a list of situations where we don't need consent to use personal information. So once again, if it's necessary for investigating contraventions of laws, an emergency that threatens life, health, or security of a person, there's some insurance exceptions here, employment exceptions, statistics or scholarly study or research purposes, things like that. And I think you're sort of picking up the general flavor that probably most, if not all, of what you do is not going to fall into very many of these exceptions, but there may be occasions where they do apply. So on disclosure, you don't need consent for disclosure where you're making disclosure to a lawyer that's retained by your organization, to comply with a warrant or a subpoena or court rules relating to production of records. Now, there may be confidentiality obligations imposed under the rules of court, but those would be it's the rules of court that would be paramount to PIPEDA when it comes to disclosing personal information without consent. Disclosure to government institutions under specific conditions that are too detailed and numerous for me to go through right now. Again, those similar sorts of exceptional circumstances. Witness statements used for insurance claims. We have that statistical, scholarly study, or research purposes again. And then this one, these two are kind of interesting, where you're making disclosure to an institution that holds records of historical or archival importance. Could happen. And then after the earlier 100 years after the record was created or 20 years after the individual's death. Again, not likely something we're going to come across very often, but it's important to know that there is this list there and it should be consulted before you make disclosure without consent. Okay, then I'm going to speak a little bit about use and disclosure without consent in the course of business transactions, a very specific exception here. Organizations who are parties to prospective or completed business transactions don't need consent to use and disclose personal information. Essentially where they're sort of doing the due diligence process that goes along with completing a business transaction. So if I'm retiring, I'm wrapping up my mediation practice, and I don't even know if this is thing, but let's say I want to sell my mediation practice, or we see it a lot with like dentists or family doctors where they will sell their practice to somebody else. As part of that due diligence process, you may want to know how many clients or patients does the vendor have, how much profit is generated off of, their use of your services. And so it will be necessary in that context to disclose that information. And that is permissible because disclosure of the personal information is necessary to let the parties decide whether they should proceed with the transaction. And the individual is notified of the disclosure within a reasonable time. The only exception here is where the purpose of the transaction is the sale of personal information, right? We generally don't want one company selling personal information to another without consent. So it needs to be incidental to, or sort of part of, a bigger business transaction rather than it being the business transaction. We also have a special category of exception here for employment relationships. Again, not really the focus, because for the most part, you're concerned about these obligations vis-a-vis the members of the public who you assist in your practices. Okay. I want to talk next. I'm leaving consent, and I'm talking now about individual right of access. As you've heard me say, individuals have a right to access their personal information as held by organizations who are subject to the Act. Organizations have a duty to assist individuals in preparing a request for their personal information. Sometimes organizations will sort of put out forms, say, if you want to access your personal information, fill in this form and send it to us. You may not need something that formal, but in order to give meaning and effect to this right to request access, we have to facilitate making the request. Once you get a request from an individual for access to their personal information, you have a duty to respond as quickly as possible, and in any event, no later than 30 days after you've got that request. Now, this timeline can be extended if, in order to respond within 30 days, it would unreasonably interfere with the organization's activities. Or you need more time to conduct consultations. Like, as you'll hear me speak about, there are situations where access can be denied. So if it's a really complicated situation, you need to consult with legal counsel, for instance, to know if you should give the information or not. That might be a reason why you can't complete it within the 30-day time frame. Or if it's necessary to convert the information to an alternate format. That might be because you collected and retained the information some time ago and it's in a different format. Pre-COVID, we did all of our things on paper. Now someone wants their information in digital format. Do you need a bit of time to digitize it? Is it on microfiche? I don't know, but this exception is there, or is a matter of accommodation. If someone needs it in a particular format to provide accommodation for a disability, that might require additional time. But if you cannot answer in the 30 days, you need to, before the 30 days is up, notify the person that you need additional time and that they have the right to complain to the Office of the Privacy Commissioner about the delay. If you've done a good job at explaining why you need the additional time and it reasonably fits within one of those categories, it's probably not going to trigger a complaint, but you have to tell them of that right in any event. if you refuse to grant access when a request is made, you have to explain your reason for refusal in writing. And then you have to give them information about their recourse to challenge your refusal. And that's all got to be done within the 30-day time limit as well, unless those exceptions apply. The Act spells out when you may not give access or when you have a right to refuse. So access is prohibited if giving access would reveal personal information about a third party. We only have the right to access information about ourselves. So if the only way to give access is to reveal information about somebody else, you may not give access. But first, you have to see whether you can sever the two. So sometimes when we make access requests, the response that will come back will have third-party information redacted, but our own information visible. So you have to see if you can sever the information first before refusing access. Access may be refused if the information is protected by a privilege known in law. Doing so would reveal confidential commercial information. Giving access could threaten the life or security of another individual. The information was collected under paragraph 7(1)(b). See if I can just remind you all, because I have not been giving the section numbers. So I'm going to pull that up. It was generated in the course of a formal dispute resolution process. That may be something that's of relevance to each of you. You know, essentially sort of without prejudice or settlement privilege could attach there. Or the information was created for purpose of making disclosure under the Public Servants Disclosure Protection Act, a very sort of narrow situation. So collecting information under paragraph 7(1)(d), that's one of the categories, 7(1)(b), that's one of the categories where organizations are allowed to collect information without knowledge or consent because it's necessary for investigating contraventions of the laws of Canada. Okay, I am running close to the hour, so I may just skip over some of this. But on access, if you don't have any personal information about a person, you need to tell them that too. You need to provide access at a minimal cost or at no cost. So you can't say, sure, we'll give it to you, but it's going to cost you, $2,000 for, inconvenience in handling. If it's a few bucks for photocopying or something like that, that's fair, but you need to tell them the cost beforehand. And you have to make sure that the information is being provided in a form that's understandable. Okay, I'm going to skip over. There's some tips there that you can consult later on about facilitating access. Talk for the remaining time about breaches and non-compliance issues. So one of our fair information principles is the need to impose safeguards to protect the personal information you hold against loss, theft, unauthorized access, copying, all of that. You need to put safeguarding measures in place. And if your security safeguards, you put them in place and they are breached, you've had a hacking incident or phishing or whatever, and somebody has gotten into your system and accessed personal information, you need to report this to the Office of the Privacy Commissioner if the breach creates a real risk of significant harm to an individual. Significant harm is not just bodily harm, although that's certainly part of it. Humiliation, damage to reputation or relationships, loss of business opportunities or employment, financial loss, identity theft, negative effects on credit record, damage to or loss of property. So it's quite a list of things that amount to significant harm. So if there's a real risk of harm to any of those categories, you must report the breach to the OPC. And you assess risk by taking into account the sensitivity of the information, the probability that, it wasn't just access, but in fact is being or could be misused. And then there's a list of other factors that inform it. In addition to reporting to the OPC where there's this real risk of significant harm, anytime your security safeguards are breached, even if you assess that it doesn't fall into that category of significant harm, you need to notify the individual. You need to give them enough information so they can understand the significance of the breach and take steps to reduce the harm for themselves. Usually, this involves some sort of a mailing, and we've all, I think, seen examples where you'll get an email saying, we have reason to believe that your information was included in a collection of information that was the target of a security breach, and here are the steps we've taken to handle it. Okay, I'm going to skip that one. I'm going to come just in the last couple of minutes to say a bit more about the role of the OPC. And I appreciate there's a heck of a lot of text on these slides. So sorry, apologies to everybody's eyesight. But just to generally explain the complaint process. And in fact, maybe I'll use the next slide. So if someone believes that an organization has failed to comply with their obligations under PIPEDA, they can file a complaint in writing to the OPC. The OPC or the commissioner themselves may initiate a complaint, even in the absence of a complaint from a member of the public, if they are satisfied that there's reasonable grounds to investigate the matter. If the complaint to the OPC arises from a refusal to give access, which I've talked about, that complaint has to be filed within 6 months or longer if the OPC allows for it. Whichever way the complaint starts, whether it's from a member of the public or it's initiated by the OPC, the commissioner has to give notice to the subject organization. That's a matter of fairness to them so they can participate in the process. And then the Act tells us that the OPC shall conduct the investigation. So it's required to investigate unless one of 3 circumstances arises. One is that the commissioner is of the opinion that there may be an alternative grievance or review process that should be exhausted first. The second one is that the commissioner is of the opinion that the complaint could be more appropriately dealt with through a procedure under a different law of Canada or the law of the province, or the commissioner decides that the complaint was not filed within a reasonable period of time after the incident that gave rise to the complaint. Once the commissioner decides to proceed with the investigation, I'm just going to go backwards. The commissioner has a bunch of powers that can be used to conduct that investigation, gather more information, and enable the OPC to decide whether there has in fact been non-compliance with PIPEDA. The commissioner does not have enforcement authority currently. So the commissioner can release a report with recommendations for the organization to take measures if the OPC feels that there has been a breach. But if the subject organization refuses to take up those recommendations, then the commissioner would need to go to court to get a court order to enforce any powers against the organization. The individual who made the complaint also has a right to seek court review if they're not satisfied with how the OPC dealt with it. So lastly, just to wrap up, the key takeaways are the need for informed consent, express consent in certain circumstances, the right of access, and I've left you with a reference for further information from the OPC's privacy guide for businesses on complying with federal privacy law. So that was a whirlwind. I'm going to take down the slides, and with the time that's left, if anyone's got any questions, I'm happy to do my best to answer them.
Thank you so much, Andrea. I think the one question I had is for our mediators. Say somebody contacts them and says, hey, you know what, I want to do mediation with my partner, and I'd like you to contact my partner to see if they would like to receive my services. What would you say to that person?
So that's a difficult one, because if someone doesn't give us their contact information proactively, you're stuck in the situation of saying, well, can I use someone's contact information to contact them in order to see if they want me to contact them? You're really in a bind there. And while I won't answer from the perspective of like what I think the OPC would say is or is not offside of PIPEDA, I will say that I think the best practice is do your best to ascertain whether you can feel comfortable that the individual probably does consent. So if a client has given you someone else's contact information and asked you to reach out to them, I think best practice is to then make some further inquiries. Do they know I'd be reaching out? Do you think I have their consent? Could you ask them to contact me first? Like, I think doing everything you can not to just make the cold call out to that person is far better. And if you've exhausted all of those and all you have is one person saying, I really want you to reach out, I think you could be getting into some trouble. If you do keep it to a minimum, just I'm reaching out to you, I got your information for this purpose, do you consent to any further engagement, and stop it there until you get a positive response.
Very good. That really is what I want our members to know about. I think that's a really key component of our jobs. Diane has raised her hand. You can unmute for a second, and I know we're kind of up to the time, but
yeah, I was just going to comment along the same lines at what Andrea does, and I would just simply what I always do is I always say, here's information about my mediation services, share this with your spouse, and then get back to me and we can work out some details. And I'm also, as a result of this presentation now, sending my privacy policy along with my intake form, which I didn't always do. I often sometimes waited till after, and I do have a privacy policy. So I'm sending it like with my intake form, complete this intake form, here's my privacy policy, and do it that way. But I would never contact someone who hasn't contacted me directly. I would always ensure that the other person say, share this with your partner, email me back.
Right. Yeah.
Excellent. That's my way of doing it as well.
Sounds good. Monica, I'll give you the last question. There's probably about 30 seconds, and then we will wrap up.
Talk as fast as I can.
Okay.
I was told many, many, many years ago that the documentation, the records that I would retain after I've destroyed my sort of notes from the intakes and so on, that I need to keep it for 7 years, and after that I can just destroy it. I don't know whether that's still relevant. That would be helpful to know, number one. And number two, to the idea of getting the information and then asking the person whether it's okay to continue with them. I would say 90% of the time when a person asks me, can you please get in touch with my partner, the other mediation partner, to ask them whether they consent to mediation, because I think it will be better coming from you than from me, I don't get them right away. I get their voicemail. So it's little tricky, but my main question is the paper trail. How long do I need to keep the paper trail? Is there any benefit to me keeping the paper trail longer than the minimum amount that there is before I can destroy it?
Yeah, I mean, retention periods, just holding the information, you're not using it, you're not disclosing it. I think there's good reason to have a retention period. 7 years is sort of the standard, whether for accounting purposes or others. At my law firm, we keep client files for at least 15 years. And that's because of certain limitation periods. Like, if you get sued, you don't want to say, I don't have the information, I purged it. And so you want to leave a comfortable period of time before you purge it. So just holding it for a reasonable retention period, I think, is fine. And that allows, if there are circumstances where PIPEDA, where the law permits disclosure, like we saw, court purposes, for instance, you are permitted to disclose it in those circumstances, and so you have it. So there's nothing wrong with holding it. The real question becomes the use or disclosure.
Very good. Very nice. Thank you so much, Andrea. I don't want to go past our time together. I think there could be 1,000 questions. You've been very gracious with sharing both the slides and allowing us to record. So if you do want a copy of the slides, like always, send me an email. Don't put it in the chat because I don't save the chat. And if you could just email me directly to director@oafm.on.ca. Thank you so much, Andrea. You've been fantastic providing us with this information. I think we're all reasonably afraid now, which is probably a good thing. So thank you. Enjoy the rest of your afternoon, and I hope to see you all again soon. Take care. Thanks.
Thanks, everybody.
Thank you.